Any mention?
Yes, please.
I think 12 for the hearing this matter. I pray, my lord, if this matter.
Yes, please. Sorry. Yes.
The board has not constituted, I think.
Which item you have mentioned?
Lord, item 12. I mentioned 4 weeks.
Yes.
Lord, may I pray, Lord, if this matter is kindly listed after 4 weeks?
Because board has not constituted yet.
Any likelihood of settlement?
We are trying to place it in the board.
We'll have it after 3 weeks then.
We'll try to sort it out.
Yes, straightforward by the learned counsel of the petitioner and not objected to by the learned senior counsel for the respondent. This is met after 3 weeks. Yes.
Much.
Your Lordship, I beg to mention item number 13. Kindly let this matter come after 2 weeks, Your Lordship.
13.
Same order, 2 weeks. Yes.
I beg.
All right, my lord.
Wait, please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 19, Your Lordship. 19, 20, and 21 is a connected matter, Your Lordship. We have already taken the consent from the other party also, Your Lordship.
19, 20, 21. These are connected
Yes,
matters.
Your Lordship, yes. I pray for 3 weeks' time, Your Lordship.
Who is the other side? Respondent?
We are there, Lordship.
No objection.
No objection.
At the prayer made on behalf of the petitioner. This is matter after 2 weeks.
Lordship.
Yes.
All right.
All 3 matters.
May I please, Your Lordship? Your Lordship, I beg to mention item number 10 and 14. This matter may be kindly taken up after 2 weeks, Your Lordship, that my senior is in this post.
No objection on our part.
This is also of the prayer of the petitioner, not objected to by the learned counsel for the respondents. This is matter after 2 weeks. And what is 14?
This one is 14 days.
This is RD number is 10. Okay, now it is 14. Who is the other side?
We are for the state only.
No objection.
Correspondent number 4, no objection.
Same order, 14. Yes.
Kindly make
Right, Lordship.
Lordship, I beg to mention item number 15, Lordship. I'm praying for 2 weeks' time, Lordship.
Who is the other side in item 15?
Your Lordship, I'm appearing for the
No
state.
objection.
No objection, Your Lordship.
Private. This is also at the request of the petitioner. List after 2 weeks.
2 weeks, Lordship. Similar prayer for item number 16, Lordship.
Item?
Item number 16.
Yeah, my lord, the matter has become infructuous because, my lord, there is a notification. They are saying to implement 5th pay commission, my lord. So we have already implemented, my lord. So the matter has become infructuous.
Is it? Has it become infructuous? Item
Yes, my
16?
lord. So let it come after 2 weeks since Mr. Sangma is not there.
You are there, Mr. Panthi, in that.
My lord, for the petitioner, my lord.
16.
Then Mr.
16
Sangma.
PT Sangma is for the petitioner.
Yes, Lordship, like this.
You are for?
My apology, my lord. Let me just check, my lord. I'm 5, my
Take
lord.
instruction. You
I'm
take
so-
instruction.
My apology, my lord. I'm for restaurant 5, my lord.
Who is respondent number 5 here? Private respondent here.
No, no, private respondent is not there, my lord. But see. See the petition.
Such paper.
Anyway, you take instruction.
Lordship, 2
Okay.
weeks.
Yes. Mr. S. Day, Learned Counsel appearing for the respondent district council submits that the matter has become infectious as the relief sought in this petition has already been extended to the petitioner. Stop. Just say learned counsel for the petitioner shall take instruction.
It appears, my lord. It appears the submission I have made, my lord, is for a different matter. This is a different matter, my lord. I'm extremely sorry, my lord.
This is
I'm
Nokma,
extremely-
lord.
This is a Nokma matter, my lord.
Just say the request to the petitioner list after 2 weeks. Kindly we
My lord.
Lordship, I also beg to mention item number 17 and 18, Lordship.
yes 17, 18.
Yes, Lordship. And for respondent number 2 here, Lordship.
No objection.
We are supposed to file the objection, Lordship. I'm praying for 2 weeks' time, Lordship.
Objection against?
In this case, for
Yes,
staying
seeking
of the criminal
stay of
proceedings,
the
my lord.
proceeding, Lordship.
Staying of the criminal proceedings, my lord. We had filed a missed case.
But this is the final thing. Is there what purpose is filing of objection? Mr. Jindal, you were also there.
My lord, I am proposed to be impleaded as I am the Lokayukta.
So you are having objection to your implement.
Against my impleadment, I have no objections. I leave it to the honorable court.
Probably your court will require your service because your authority is under
Possibly, possibly. So I leave it to my lords.
Your participation may help us to a great extent.
Possible. Yes, ma'am.
So anyway, just we'll keep it pending then.
2 weeks' time, Lordship.
Lordship,
My lord, the interim prayer may be extended.
Okay, I just say as prayed for by Ms. So and so, learned counsel appearing for the respondent. And this is matter after 2 weeks. Stop. The interim order passed earlier shall continue till then.
Good evening, my lord.
No objection.
May it please your lordship, I beg to mention item number 22, your lordship. Kindly the matter may come up after 2 weeks, your lordship. I have already taken the consent of the opposite counsel, your lordship.
Okay. As a request to the petition after 2 weeks. Item 22.
Highly obliged, your lordship.
Item number 1.
Yes.
My lord, we've come against the order passed by the district council court, my lord. Well, here what happened, my lord?
This is civil revision.
Civil revision, my lord, under Rule 6 of the.
Against the order passed by Judge District Council. Yes.
But the valuation was below 1 lakh rupees, my lord, so we could not file an appeal. So we come by way of revision. So the Rule 6 of the.
Rule 6.
Rule 3, my lord, under which the appeal lies, my lord.
Yes.
It says, my lord, the valuation at more than 1 lakh rupees can be by way of appeal, and below 1 lakh rupees, the only remedy is by revision, my lord.
In Rule 6, then such restriction is there.
Rule 3, there is restriction, my lord.
The Rule 3 is appeal, but then Rule 6, otherwise I don't think there is any bar. There is.
Rule 6, there is no restriction, my lord. Rule 3 says, an appeal against a final order of decision of a district council court in a civil suit where the valuation of the suit is rupees 1 lakh or more.
Oh, this is not against the original order passed by the judge.
No, this is an appellate order.
Against appellate order. Anyway, scope will be more or less same. If you come here also, there will be second appeal. And then Rule 6 also, you'll have to confine yourself to 115.
Well,
yes.
Well, here what happened, well, the respondent filed a civil suit, my lord, before the presiding officer. The petitioner, after receiving notice, that was the COVID period, my lord. Around 2020, the suit was instituted. When the defendant is a villager, my lord, this is a 61-year-old illiterate person in a remote village, my lord. Now, when she received notice, she personally came to appear before the court and requested for some time to engage a counsel, my lord. That I'll point out that particular order, my lord. After that, what happened?
There was a suit for eviction.
Suit for declaration, my lord. And eviction also, for position, my lord.
And for permanent injunction.
Permanent injunction also. Now, my lord, after that, what happened, my lord, the suit was transferred from one court to the other court within the district council only, from one presiding officer to another presiding officer. The second presiding officer also issued notice Now it appears that being in the remote village, my lord, notices were not served for quite some time. Many dates notice returned unserved, my lord. But eventually the notice was served. She engaged a counsel, my lord. But what happened, my lord? The counsel never filed a written statement on one pretext or other. Whereas the revisional petitioner instructed, gave all the papers to the counsel, but the counsel never filed. Now trial court proceeded ex parte, my lord, passed an ex parte decree. Against that, we filed an appeal before the Judge District Council Court, my lord. Now the Judge District Council Court dismissed our appeal, my lord. Against that order we have come, and after dismissal of this, my lord, they have filed an
ex parte order. Ex parte order.
ex parte decree, my lord.
Ex parte decree.
My lord.
The appellate court did not interfere.
Appellate court says that counsel is also responsible, but on what basis? I'll take your lordship to the operative part of the appellate order, my lord. At page 199, my lord. Yes, 199 are the findings, my lord.
Yes.
Para 7 onwards. It is found that the learned trial court below have proceeded the suit ex parte against the appellant defendant, and subsequently an ex parte judgment order has been passed, and the decree for execution has been proceeded, and the handing over of the bailiff is completed. As the instant appeal has been prepared mainly on the issue of the ex parte proceeding and ex parte judgment order. Now kindly mark, my lord. Therefore, I will not dwell this appeal on the merits of the case. However, I will discuss the same on the point as to whether the appellant have sufficient reason for vacating the ex parte judgment. Now, the premise itself is wrong, madam. We are on appeal. We have not filed an application under Order 9 rules.
The court has dismissed the appeal without considering the merit of the case.
Without considering the merit and without anything, my lord.
Who is the other side?
But the other side notice has to go, my lord. My lord, what is more important, my lord? The learned trial court is referred to at page 202, my lord.
Yes.
At para 13, they have referred to the Honorable Supreme Court in a case arising out of SLP number so and so in Rajneesh Kumar versus Ved Prakash have observed, putting the entire blame upon the advocate and trying to make it as if they were totally unaware of the nature and significance of the proceedings is a theory which cannot be accepted and might or not have been accepted. Then it says, in the light of the other findings, I am hereby satisfied that there is no irregularities in passing the ex parte impugn judgment an order dated 11/8/23 by the learned trial court, which requires interference with this court. Therefore, the appeal is dismissed. Now, my lord, this very judgment which the learned judge is referred to, talks in my favor. If I just place it out, though it may not be this, but I'll just. It's a little interesting, my lord.
Even for the ex parte decree, the appellate court was duty bound to give a decision on merit. That is what thing
in my humble submission,
appears to be involved.
There are two aspects, my lord. That either the appellate could have remanded back the matter, allowing us to file a written statement.
Normally, that is what is done in ex parte, because in law, ex parte decree is not held to be a very good.
No, my lord.
Law requires that thing should be decided on.
Now,
will issue not issue, just see.
But here what happened, my lord, they filed execution proceedings and they issued a notice, my lord, page 205, lots of kindly sees, my lord.
Execution notice within 2 years. Again, why notice is needed?
No, my lord, they are trying to evict, my lord. There are some tenants, the farmers.
That is personal notice.
Personal notice, my lord.
Anyway, this will give you a separate cause of action, filing another suit. Anyway, heard Mr. Dr. Magical Learned Senior Counsel, assisted by suit. Issue notice, returnable in 3 weeks. Step for service of notice upon. How many respondents are there?
There are 3, in fact, my lord. The third is pro forma respondent, same of career.
You have to serve notice. Steps for service of notice upon the respondents within 2 days. List after 3 weeks.
I'm praying for some interim, my lord.
You filed a separate case.
You filed.
There also write same thing, issue notice. Heard Dr. Mojiga, learned counsel appear for the applicant, issue notice. list along with give main case, list along with the connected CRP number 3 up to 125. Will maintain status quo instead of saying till the
My lord, the status quo might create some difficulty, my lord, because there are
if you are not in, if you are in position, it should not create any difficulty.
no coercive action, my lord, for to evict it.
Same thing.
Well,
till the return verdict, comma, the status quo with regard to the suit property shall be maintained by the parties. Till the interpret the status quo with regard to the suit property shall be maintained by the parties. Yes, all right. That will be take steps.
well. Deeply.
Item number 2.
Yes. Another CRP.
Your Lordship, in this matter, Your Lordship, I pray that I may be allowed to withdraw the petition with liberty to file a fresh, Your Lordship.
Why? What
Some
happened?
technical defects were there, Your Lordship, in the petition, because we came under section Article 227. Your Lordship, we were not aware with the judgment of this Honourable Court, Your Lordship, that the proceedings under for quashing, Your Lordship, should be in the 482, Your Lordship.
Is there any judgment by this court with regard to
This
this?
court, Your Lordship.
Are you sure?
Yes, Your Lordship.
Well, you are appealing for the
For
respondents.
respondent number 1, Your Lordship.
Okay. Madam Counsel, appealing for the petitioner submits that there is some defect in the petition which needs to be corrected and praise for withdrawal of the same with liberty to request. Prayer allowed. This petition stand dismissed on withdrawal with liberty as prayed for. Yes.
Item number 3.
Yes.
Please, Your Lordship. This is an application invoking the inherent powers of this Honourable Court, my Lord, questioning certain orders that were passed in a CR case, in a criminal proceeding, my Lord. It arises out of a domestic dispute. The petitioner was married to the respondent number 4 in Bihar. There was a fallout. She was subjected to a lot of violence and torture. She fled that home and she took refuge in her paternal home in Shillong. Thereafter, she consulted counsel and she filed 2 cases, my lord. One CR case under the Domestic Violence Act, which is pending disposal before the court of the JMFC in Shillong, and another CR case was filed, my lords, under section 498A, 506, etc. And that was also filed before the court of the CJM. That will kindly have page 36. These are complaints under section 200, my lord. So this is the first order which was passed by the learned CGN endorsing the case to the court of the JMFC. This reads, this is an order dated 1/11/22. This is received complaint registration under section 200 CRPC for taking cognizance of the offence under so and so and section 4 of the Dowry Prohibition Act 1961. Register the case to so and so JMFC Shillong for disposal.
You are reading which page?
That's page 36.
Yes.
Lordships have it?
Yes.
So this was endorsed to the court of the JMFC. The next order Lordships will find is at page 37.
Yes.
On the very same day, the learned JMFC passed this particular order. Order dated 1/11/22.
After being matter was endorsed.
My lords, after it was endorsed. Case record is put up before me today. Seen the endorsement of the case by the learned CGM Shillong for disposal in accordance with law. A complaint has been made in writing by the complainant so-and-so. Her learned counsel so-and-so has filed wakalatnama to represent her. I have perused through the written complaint. The complaint alleges the commission of offences punishable under so and so provisions of the Act. We may refer to the decision of the Honourable Supreme Court in the case of so and so, wherein the Apex Court observed, if on a reading of the complaint he finds that the allegations therein disclose a cognizable offence and the forwarding of the complaint to the police for investigation under section 156(3) will be conducive to justice and save the valuable time of the magistrate from being wasted in inquiring into the matter, which was primarily the duty of the police to investigate, he will be justified in adopting that course as an alternative for taking cognizance of the offence himself. Since the matter is at a precognizant stage and considering the nature of the assertions made, including of offence of rape apart from cheating and dishonest misappropriation of property and other offences, I find it expedient and necessary that in exercise of the powers under 156(3) CRPC, the incident complaint be forwarded to the officer in charge of the Lumdingiri police station for investigation into the facts borne out in the complaint. Send a copy of this order to the OC of the Lumdingiri police station, so and so. Can you see the next line, Manoj?
Yes.
The CR complaint number so and so is accordingly disposed on the complaint being forwarded to the officer in charge of the Lumdingiri police stations. There are two things with this particular order, Manoj. Number one, there is no dispute that even in a proceeding under section 200, the court has the power at a precognizant stage to invoke 156(3) and transfer the matter to the police for investigation. But this requires proper reasoning, and that reasoning has to be reflected in the order. In my humble submission, my lords, there is no reasoning reflected in this order, save and except what lordships will find in para 6 says that I find it expedient and necessary. This is not sufficient at all.
Well, there has to be elaborate.
Well, I'll just refer to a decision. There are certain parameters. 2015 6 SEC 439.
Yes.
Well, Lord, will please have page number 17, para 20. Sorry, page 455.
Yes,
My lord has it. Para 20, page 455. This reads, it has been held for the same reason that direction by the magistrate for investigation under section 156(3) cannot be given mechanically. In Anil Kumar, it was observed as follows. The scope of section 156(3) CRPC came up for consideration before this court in several cases. This court in Maqsood Syed's case examined the requirement of the application of mind by the magistrate before exercising jurisdiction under section 156(3) and held that where jurisdiction is exercised on the complaint filed in terms of section 156(3) or section 200 CRPC, the magistrate is required to apply his mind. In such a case, the special judicial magistrate cannot refer the matter under section 156(3) against a public servant without a valid sanction order. The application of mind by the magistrate should be reflected in the order. The mere statement that he has gone through the complaint documents and heard the complainant as such as reflected in the order will not be sufficient. After going through the complaint documents and hearing the complainant, what weighed with the magistrate to order investigation under 156(3) CRPC should be reflected in the order through a detailed expression of its views is neither required nor warranted. So it's not detailed, but
there are certain things you see, even at the stage of issuance of process or say for ordering, if a detailed order is to be recorded,
Lordship,
then we do not know. There are.
I agree, my lord. But my lords will see what is the reasoning here. It only says it is expedient and necessary.
What matters is that the magistrate should apply his mind.
In my humble submission, there was no application of mind.
Any kind of order.
Lordship.
Before issuing any kind of order, whether it is in relation to issue of process or in relation to ordering investigation by police authority,
Lordship.
definitely magistrate should apply to the certain situation of the case.
Lordship.
It is not that
my lord.
What you say, but then doesn't mean that the court has to give an elaborate reasoning.
True, my lords. I'm not saying it requires an elaborate reasoning, but there is no reasoning at all in this case. My lords will see, there is no discussion at all as to what weighed on the mind of the court. That is what ought to be reflected, that has not been reflected here, in my humble submission. Furthermore, at para 8 lordships will find, the complaint petition was disposed of without awaiting for a report.
That should not be.
Ideally, a report should have been called for. Now, thereafter what happens? The matter is sent to the Lumdingiri police station. This doesn't end here. And my lord, this order is from 2022.
What you are challenging then?
I'm coming further. I'm the complainant.
You are the complainant.
I'm the complainant. So, pursuant to this order.
You are challenging the order obtained by you.
Lordship.
You are challenging the order obtained by you.
No, I'm not just challenging this order. There is a subsequent order, my lords, where the complaint was transferred to Bihar.
This order dated 1/11/2022 was passed at your instance.
No, not at my instance, on my complaint. Of course, I was not heard.
So that is what you wanted, but then you wanted the court to pass some order, isn't it?
Yes, under 200.
So that is what you approach the court. Your instance means you approach the court.
On my application, yes. On my application.
And then what happened? The court disposed it of.
It disposed on the very first day.
But then this is in 2022.
Correct, my lords. In 2022. I'm just coming to that one. So pursuant to this order, the matter went to the Lumdingiri police station. They registered a PS case on the basis of this order, and they started investigation. They got in touch with me, and we proceeded to Bihar for an investigation. They went to the matrimonial home and they took the statements of several witnesses. Now, thereafter, I have no further participation in this matter. Then kindly see at page 38.
Yes.
Lordship have it. Page 38, annexure 6. This is a letter which is addressed to me by the Lumdingiri police station, the women police officer.
Yes.
Now, this is a letter dated 22nd of January 2024.
Yes.
But at the same time, there is a conflict with the date. Your Lordship will see at the signature at the bottom, there is a different date, 22/1/23. This is an incorrect date. I was actually served this order, this order is dated 22nd of January 2024. Now, this is can you see the subject? Intimation under section 173, Roman 2. It should be 173 subsection 2, Roman 2 of the CRPC. So, this is with reference to PS case, which was registered pursuant to the previous order. This reads, Madam, with reference to the subject cited above, I am to inform that during the course of investigation in connection with the above referred case, the entire course of action is at Muzaffarpur, Bihar, and the investigating agencies in Shillong lack territorial jurisdiction to carry out the investigation in this case. Hence, case has been transferred to Maniari Police Station, Muzaffarpur, Bihar on 10/1/24 for further investigation as per court order dated 2/5/2023 passed by so-and-so CGM Shillong. In this connection, you may pursue the case before the competent investigating agencies in Bihar if required, submitted for favor of your kind information and necessary action. So, my lords will see that pursuant to this order, some investigation occurred, and thereafter, there was an order dated 2/5/23 passed by the learned CGM transferring the case to Bihar, transferring the investigation. Kindly take note of that. Transferring the investigation, and 8 months thereafter,
basing on this letter.
Yes, not basing on this letter. I'm just coming to some other letter because thereafter I filed.
So see, matters to disposed of.
Yes.
Rightly or wrongly, you don't know.
Yes.
And thereafter, as a result of outcome of investigation, you received this letter.
I received this letter.
Saying that the matter has been transferred to Bihar.
And just see the dates, my lord. I am informed about it on 22nd January 2024 that on 2nd of May 23, a judicial order has been passed transferring the investigation to Bihar. The last line in that first paragraph, as per court order dated 2/5/23, passed by the learned CGM.
Yes.
So, in the month of May 23, some judicial order is passed transferring the investigation to Bihar. I am informed about it only in 22nd January 2024. So, thereafter, I filed certified copy application forms and so on, and it took a very long time to obtain it because it turns out that eventually this particular order of 2/5/23 was not filed in the complaint case. It was filed in a PS case. So there was some confusion. The record room had to look for the records, and eventually I found the details. So my lords will kindly have page 47.
Yes.
So after obtaining the records, it turns out an intimation was sent by the Lumdingiri police station to the learned CGM, and this is at page 47. This is dated 28/4/2023. There is nothing on the body except the receipt, where at the signature of the acknowledgement, the date is mentioned, 28/4/2023. So this, my lords, is addressed to the learned CGM Shillong. Subject intimation, again reference Lumdingiri PS case number. Madam, in inviting you the subject cited herein above, I the undersigned, I would like to intimate your honor that during the course of investigation, I have personally gone to Muzaffarpur, Bihar for the purpose of collecting evidences and recording the statement for the interest of the investigation of the case, and during such period and during the course of investigation, I have personally recorded the statements of the available witnesses connected with the case and all the statements recorded under 161 CRPC. it is found that the entire cause of action occurred in Muzaffarpur, Bihar. As such, the investigating agency lacked territorial jurisdiction to carry out with the investigation of the case. As such, I, the undersigned, humbly praise before Your Honor to pass necessary order in this regard, to the extent that the complainant, if she wishes to pursue with the case, she can at liberty to approach the competent investigating agency at Bihar for the purpose of redressal of her grievances in accordance with law, submitted for favor of your kind information pertaining to the current status of the investigation of the case. In my humble submission, Lord, there is no question of referring this particular matter to the learned CJM. The CJM does not have the power to deal with it, cannot even assume jurisdiction of the matter. The pursuant to this, an order is passed at page 48, order dated 2/5/23.
Yes.
This reads, record put up before me, this is by the learned CJM. Seen and perused the intimation dated 28/4/23 by the IO so-and-so of Lumdinjiri PS, wherein she stated that during the course of investigation of the case, she had personally gone to Muzaffarpur, Bihar for the purpose of collecting evidence and recording the statement. She had personally recorded the statement of available witnesses under 161 CRPC, and it is found that the entire course of action is at Muzaffarpur, Bihar. In view of the above circumstances, the IO has prayed before this court to pass necessary orders to the extent that if the complainant wishes, she can pursue the case before the competent investigating agency in Bihar, as the investigating agencies in Shillong lack territorial jurisdiction to carry on the investigation in this case. On perusal of the material on record and on consideration of the prayer of the IO, this court has observed that the PO in the case, place of occurrence in this case, is Muzaffarpur, Bihar, but the complainant so-and-so, who is residing at Barapathar, Shillong, before a marriage to the alleged accused person number 1, resident of Muzaffarpur, Bihar, has filed the instant case before the court under 200 CRPC, and thereafter the learned code of JMFC has forwarded the complaint to OC Lumdinjiri PS for registering an FIR and for investigation of the same. In consideration of the prayer made by the IO, this court has also observed that the cause of action in this case has arisen at Muzaffarpur, Bihar, when the complainant, after her marriage, started residing in her matrimonial home at Bihar with her husband, the alleged accused number 1, and all the witnesses in this case are from Bihar. Hence, the investigating agency and the court of Shillong, Meghalaya do not have jurisdiction for investigation and trial of the instant case. In view of the above observation made by the IO of this case, it is directed to forward the FIR, the complaint under 200 and all relevant documents, along with the statement of all the witnesses recorded by her, to the concerned and competent PS at Muzaffarpur, Bihar, to take cognizance of the case and to expedite investigation and submission of FF before the court having competent jurisdiction for trial of the case at Bihar. IO to take necessary steps to inform about the transfer of the case to the complainant. First thing, even if the court assumes jurisdiction of the matter and considering the statute allows it, I should have been informed about it. It affects my rights in some way.
Whether court can transfer the matter
It cannot.
outside this
No,
state?
it cannot. Even the Honorable Supreme Court does not have the power under Section 406 to transfer an investigation. What they can transfer is a trial inquiry, cases appeals, but not an investigation. It has very recently been ruled. Only under in exercise of powers under
Law is very much
Article.
clear. Even High Court also cannot transfer one
Cannot
FIR
transfer
from one state to another.
Exactly. So just coming. There are multiple reasons why this order is highly erroneous.
So anyway, what is your prayer at this stage?
My prayer is to set this aside, my lord.
We have to issue notice.
Yes, my lord. To issue notice. I have to satisfy lordships that have at least made out some
it
case.
seems to be, but then it's what is the procedure followed? That becomes very confusing. You see, if you go through which way the matter has been treated.
Lordship.
Yes.
We are appearing on behalf of the respondents 1, 2 and 3.
How it happens?
I'm not aware of that.
See from your investigation to the order passed by the court.
By the CGM.
At this stage, we can issue notice on that.
Lordship.
To the private respondents,
But
we
private
accept
respondent
notice
4,
for
5
1
and
to
6,
3.
my lord.
Heard Mr. SL, conduct counsel appealing for the petitioner. Issue notice returnable in 3 weeks. University Yangi, along with Mr. Ranger, appears for respondent number 1, 2, and 3. Stop. The petitioner shall take steps for service of notice upon the respondent number 4, 5, and 6 within 2 days. List after 3 weeks.
Item number 4.
Pleasure.
Please, Your Lordship.
Yes.
Well, the trial court records that only half of the trial court record has come, my lord. The ejectment suit record has not come. Miss case number 78 also has not come, my lord.
This is a revision against what order?
Well, what had happened is that.
Oh, this is not for motion, isn't it? This is
no, my lord. Notice has already been issued. They have appeared, my lord.
This is a revision against order passed by the judge.
Judge.
Appellate order.
Appellate order. My lord, what had happened is that I had filed an application for deposit of rent before the trial court on the title suit which was filed by me for declaration as well as for ejectment, my lord. That was refused by the trial court. Then I went to the appellate court against that order, my lord. The appellate court also has rejected my application, my lord. That's why I am before your lordship.
So your coming is concurrent decision to
my lord. The ejectment suit for 2022 has not come, and the miss case which was filed by me before the trial court also, that also the record has not come. We will provide the suit number as well as the miss case number and the court number. The matter can be listed after 2 weeks once the records are there for final hearing.
Yes.
Yes, Lordship. I have no issue on that, Lordship.
Okay, it is Mr. L. Khariam, Lord Counsel for the petitioner submits that though the official note dated 16/1/2024 indicated that the lower court records have been received, the record of
the trial court, the hearing of
just give us the number, which number?
Ejectment suit number 4 of 2022 and miss case number 78 of 2022
has not been received. That will be received from the judge, court of the judge.
It will come from the presiding officer. What had happened is that after the appeal was decided,
when you file the appeal, the appellate court says the trial court. So it should be together, isn't it?
No, what had happened is that after the appeal was dismissed, my appeal was dismissed, the record was remanded back to the trial court.
Okay.
After that, I had come before this court.
What is it? Just although the record of such and such something has not been received, the Learned Counsel submits that the aforesaid records would be necessary before the matter is taken up for further consideration. The Learned Counsel appearing for the respondent does not dispute the submission made by the petitioner. Accordingly, let the records of such and such just give that numbers which you are giving earlier.
Well, I have given the subject as well as the code.
We called from the concerned court. Let this matter be listed immediately after receipt of the record. The aforesaid record.
Obliged.
Yes.
Item number 5.
We'll have it after 2 weeks then, Mr. Kerem. You just let this matter after 2 weeks. Yes. Instead of saying that after receipt of this, just listen. Yes.
Lordship, the state has to take instruction and they have to file affidavit, sir.
Lordship, in this matter, I'll take instruction.
Yes. You have not taken in. Yeah.
No, Lordship.
So you
2 weeks time.
Yes, Mr. H. Karmi, learned additional PP. Praised for and granted further 2 weeks time for taking instruction in this matter. List accordingly. Yes.
Item number 6.
Well, I was supposed to file the previous service, my lord.
Yes.
On 1 to 4, my lord.
Yes.
Was out of station, but I'm filing course today, my lord. I'm filing it in the course today, my lord.
Yes, the Lana Council was the petition of 6. We have to have some more time for filing an affidavit of service in terms of the previous order. You have no objection, I believe?
No, my lord. Hearing for the respondent number 6.
Accordingly, list this matter after everything. You file it? She filed the affidavit.
Obliged.
Item number 8.
My lord, this matter, private respondent was supposed to file an objection to our petition, my lord. But
My lord, private respondent, my lord, we are not in a position to file our objection. She is paralyzed. She has been paralyzed for quite some time. Doesn't look like she's improving also. So matter may proceed, may be fixed for hearing. We'll make submissions based on law, my lord. Actually, we obviously cannot submit.
Mr. Jindal Learned Council appearing for the respondent number 2 submits that due to ailment of the respondent number 2, she or he is unable to file any written objection against the criminal petition before this court. He submits that the matter may proceed for hearing on the basis of the materials, on record which are already there. Then you say, in view of the submission, that this matter will be listed for hearing when?
2 weeks, ma'am.
after 3 weeks, ma'am.
After 3 weeks. After 3 weeks. Yes.
Item number 9.
Yes.
May I please, your lordship? Let this matter must become after 1 week, lordship. Conducting counsel is out of station, lordship.
What is the matter about?
Restoration, lordship.
Restoration of the petition dismissed for default.
Yes, my lord.
Yes, lordship.
So why we are awaiting for documents and all of the previous day? If you see, Mr. Dev, the last occasion or before that, you needed some documents to be supplied to you, and it was accordingly supplied to you.
Yes.
This can be heard. I have received the instruction, my lord.
10/12/2024.
Yes.
Okay. So this is restoration.
This is restoration.
That is for sure, isn't it?
Yes, yes.
No confusion.
No, no.
Okay. Just say a speak for with the learned counsel for the petitioner. This is matter after
2 weeks also.
after 2 weeks. Yes. State is also a party here.
Yes, Hello, bless lordship.
Hearing item number 11.
Yes. You want to say something? Oh,
No, lordship.
there is no petitioner.
No,
So
lordship.
it goes to your advantage.
Yes, lordship.
None appears for the petitioner. MS so and so is present on behalf of the respondent. List this matter after 3 weeks.
Lordship, yes.
Item number 23.
Yes.
May I please, your lordship? My lord, this is a case for quashing of the criminal proceeding pending before the London Magistrate, Ceylon. This page number 14, your lordship, the FIR. The offence is 465 and 471, the punishment of which 2 years or fine or with both.
Yes.
Page number 14, Your Lordship, the FIR.
Page 14, 1-4.
Yes, Your Lordship.
Yes.
My lord, the allegation is that with reference to the subject cited above, I, Emmanuel Sam, have the honor to inform you that on such and such 17/1/2022, the executive member of Mopdang village has informed me that my signature appear on the document of no objection certificate NOC and the land ownership certificate based on the document of the land at Moknor, Mopdang village with no specific date, which was signed by Sri Isaac CM, the ex-headman, and Sri Styling CM, the ex-secretary of Mopdang village, and the witnesses have been given by my name, Emmanuel CM. On behalf of this document, I totally reject with the signature because it is not signed by me. My lord, this is the NOC I have enclosed and the signature where it appears, page number 10. This is the NOC, Your Lordship, where this...
You are named here in this FIR.
No, my lord, I am not named here. The allegation is that I am the petitioner number 1. The mother of the son of the petitioner number 1 is the son of one lady, the lady in whose name the certificate is issued. This is this complainant is the sister or brother of the person in whose name this NOC has been issued.
How many petitioners are there?
There are three petitioners.
Yes.
None
of them are named here in the...
No, there are no named. But the allegation is that only because, Your Lordship, will find that in the his Emmanuel CM, his signature is appearing there. That's why he is aggrieved, the complainant. And he has filed this FIR because he said that I have not signed this NOC.
Just a minute. So complaint was basically with regard to the appearance of signature in the witness column.
Yes.
The complainant says that my name appeared on certain document as a witness.
Yes.
Which I have not signed.
Not signed. That is the in respect of NOC was issued in respect of for registering a land in the name of his sister only.
Of this complainant sister.
Complainant sister. Youngest, she is the youngest daughter or
he
youngest.
did not witness. Okay.
Yes, that is the only allegation. But, Your Lordship, and thereafter the case was registered under section 465 and 471 for forgery. The case was also charge sheeted and they entered appearance on being summoned.
Charge sheeted, you are named there. You all are named.
Yes, my name.
The charge sheet you appeared as.
Yes. My name is there and this Secretary Snong and Darbar Snong.
And you all are related to that person.
Yes, we are all the family members. Even the Darbar Snong, Secretary Snong, all we are family members. So now, Your Lordship, after filing of the charge sheet, it is alleged that this was signed in the year 2005.
Okay. Now you are seeking quashing on what ground?
Based on settlement. Because
settlement?
Yes. Both the parties, they have settled because this is a are from family.
What is the punishment? Maximum punishment?
Maximum punishment is 2 years or fine or with both.
470 and 465.
Yes.
State has any objection?
My lord, we had done our job, my lord, after receiving of the complaint. After investigation, we
What
had
about
filed
the compromise settlement?
My lord, what my learned friend is now bringing, what are the reasons why they have entered into
you have seen the settlement agreement, see, isn't it? Has it been appended here?
Yes, I have.
Now, what is your reaction to that? That is what you give it. Where is that settlement deed? Oh, that
page 26, my lord. Page 27.
What is the law, relevant law in this regard, Mr.
My lord, I feel, my lord, after the charge sheet has already been filed, evidence is to be started, my lord, and this is not the stage, my lord. We should not entertain this petition at this stage, my lord.
Why?
Because in the trial it will come to know what.
What about the compromise?
My lord,
We
compromise.
are not fixing. We are not talking about the wrongdoing or innocence of any party. We are not at all concerned with this. We say that who is the private respondent? Yes. What do you say? What do you say? What is your say on the prayer made by the? Okay, so that means there appears to be a valid settlement. Okay, there must be a settlement. We are not saying valid settlement. Let us not say. Now, what is your problem with the settlement? We are not on the issue whether who is guilty or who is not guilty. That we cannot decide here.
My lord, our duty was to find out the truth, my lord, and in our endeavor to find the truth, my lord, we had filed the charge sheet.
So you are going traveling somewhere else. We just tell us what is your reaction to the compromise. Can we accept it, or can we? If we cannot accept it, then what is the reason?
My lord, I'll have to do some more research on this. Today I have not come prepared on.
So it means you are there to raise objection.
Yes, my lord.
Give us the law. What is the law? Gyanshing and
yes,
what?
Yes, my lord.
Only the Gyanshing. And you have not brought that?
I have also brought the recent one, your lordship. This is just February 2025.
That is also the same thing.
Yes, yes. And this.
What is the relevant paragraph in Gyanshing?
57 and 58, your lordship.
Give me a copy. How many you have given? This is Gyanshing. In that new decision, what is the new paragraph? What is the paragraph?
In this case, your lordship, the reference has been made with regard to Gyanshing's case also.
This has followed the proposition laid down in Gyanshing's case.
Yes, yes. Paragraph number 6, my lord. And certain guidelines, again, it has been mentioned here.
Which case is not compoundable? Which section is not compoundable?
The cases which are heinous, my lord. This case was
no. In your case,
yes, my lord.
This
468, 465 is not compoundable. Although punishment is like that, but it is not compoundable.
This paragraph 57 has been reflected on.
Yes, yes, 57 and 58.
Yes.
And my lord, this new one, I'll just refer paragraph number 10. It was 307, your lordship, it was converted to 326, the punishment of which 10 years. And then also, your lordship, it was quashed. Paragraph number 9, I'll read your lordship first.
Yes.
Will the mere mention of section 307 IPC in the criminal proceeding force the court to adopt a hand-off approach when parties come forward with a settlement? In that event, what would be the duty of court, and what are the tests to be applied to decide in which cases settlement would be accepted and which cases it would not be? In state of Madhya Pradesh versus Lakshmi Narayan and others, 2019 5 SCC 688, after discussing the ratio in Narendra Singh and others versus state of Punjab and another, 2014 6 SCC 466 and other judgment, this court held, considering the law on point and other decision of this court on the point referred to herein, it is observed and held as under that the power conferred under section 482 of the code to quash the criminal proceeding for non-compoundable offence under section 320 of the code can be exercised having overwhelming and predominantly the civil character, particularly those arising out of commercial transaction or arising out of matrimonial relation or family dispute, and when the parties have resolved the entire dispute among themselves. Such power is not to be exercised in those prosecutions which involve heinous and serious offences of mental depravity or offence like murder, rape, dacoity, etc. Such offences are not private in nature and have a serious impact on the society. Similarly, such power is not to be exercised for the offence under the special statutes like Prevention of Corruption Act or the offence committed by public servant while working in that capacity are not to be quashed merely on the basis of compromise between the victim and the offender. So, my lord, my case is squarely covered under the, because this is not fall under the category of heinous or a special statute. It is a family dispute. Because of that, this FIR was lodged. Now, offences under Section 307 IPC and the Arms Act, etc., would fall in the category of heinous and serious offences, and therefore are to be treated as crime against the society and not against the individual alone, and therefore the criminal proceeding for the offence under Section 307 IPC and or the Arms Act, etc., which have a serious impact on the society, cannot be quashed in exercise of power under Section 482 of the Code.
You can skip this. This is totally 307.
Yes. But it was also converted in this case, my lord.
That
It
is
was
also 307. You have nothing
nothing to do. Yes.
307.
So the law is settled, your lordship, because this is a minor punishment is also very minor, your lordship, even for fine. But your lordship, if your lordship will allow, then it will bring peace and harmony in the family. And they are from the same village, same family. Your lordship, continuation of the proceeding, it will not be much in the interest of justice.
No, whether you are wanted in some other criminal
No,
cases.
I have specifically mentioned, your lordship, that I have no criminal antecedents.
Yes, Mr. Shankar.
Yes, my lord, insofar as the judgment is concerned, it's very clear that if it is not so heinous offence, my lord, but
so in that view of the matter, you will not have any objection.
I have to leave to the discussion of this honorable court, my lord.
Okay. Yes. Third, Mr. S. Pandit, learned counsel for the petitioner. Also, Mr. S. Sangupta, learned additional senior PP.
Additional PP.
Additional PP. And Chirmang. You are from Jaintia? Yes, Chirmang. For the private restaurant number 2. Yes. All right, sit down, take your seat. Yeah, paragraph. This is Mr. Pandit, learned counsel for the petitioners. Huh? There are many petitioners. Give a paragraph, then you say. And FIR dated. Just the fact of the case is that on 11/2/2022, the respondent number 2 lodged one FIR to the officer in charge, Dieng Paso Police Station. Officer in charge, Dieng Paso Police Station, to the effect that his signature was forged on a document of no objection certificate and the land ownership certificate, based on which the land at Maknor, MAWKNOR, within bracket you write Mapdang, MAWPDANG. You will get it in the FIR at page 14. was Acha, Mapdang village, na? Village, you have said village? Okay, village. Mapdang village was signed by the ex-headman and ex-secretary of the village. Stop. On the basis of the FIR. What is the case number which was registered?
Yes.
Young Paso PS case number 04 within bracket 02 2022 under section 465/471 IPC was registered and investigated into. What is the status of the case now?
It is for explanation of substance of charge.
The charge is not yet framed.
No, because this is 3 years below, so only explanation.
Only explanation. Framing of charge is not necessary.
Not.
This will go as
Summary.
Summons trial.
Summons.
Yes. And matter after completion of the investigation, my charge sheet was forwarded to the trial court by naming the petitioners herein as the accused. The charge sheet was forwarded by just say by charge sheet number 3 of 2024 dated 28/01/2024 under section 465/470 same section. Okay. By naming such and such. Okay. And the matter is now pending trial before
Magistrate first class K.E. Rimbai.
Before the learned judicial magistrate first class at Shillong. If there is some missing part, just sentence, arrange the sentence properly. Stop. It appears that a settlement meanwhile the petitioners and the respondent number 2 have entered into a settlement stroke compromise by a settlement dated 28/11/2024 whereby they mutually agreed to compromise the matter and not to proceed the criminal trial. Stop. Since section 465 IPC involves since the offence under section 465 IPC is non-compoundable, the petitioners had to approach this court for acceptance of settlement and quashing of the criminal trial against them. Stop. Paragraph. Mr. Pandit, Learned Counsel for the petitioner, submits that the petitioners and the respondents are closely related to each other, and the FIR was filed under some misconception by the respondent number 2. He submits that the dispute involved in the present case is purely private in nature, having no impact in the society, and since the parties to the dispute have settled the matter, any further proceeding in the criminal trial will not serve any meaningful purpose. Stop. He, therefore, prays that the further proceeding of GR case number 3 within bracket A of 2024 pending before the London Court of Judicial Magistrate First Class, Shillong, be quashed. You see, earlier part where we said with the fact part that the matter is pending, a charge sheet has been filed and all, the matter is pending trial. Matter is pending trial in, you write GR case number 3 of 2024. This number has to be entered somewhere in the top. Okay? Just see this and then we do it. Step. A paragraph. Mr. S. Sangupta landed additional PP in his fairness submitted that since the parties to the dispute have already settled the matter, he does not have any strong objection against the prayer made. Just stop paragraph. Then give a paragraph. MS Chirmang learned counsel appearing for the respondent number 2 supports the submission made on behalf of the petitioners and also acknowledges that a compromise has already been attained in the matter. Stop. She submits that the respondent number 2 is not willing to pursue the matter anymore before any criminal court. And will not have any objection if the proceeding before the trial court closed on the basis of the compromise dated 28/11. Do not say on the basis of settlement. Do not say compromise. Settlement dated on the basis of the settlement deed dated 28/11/2024. Give a paragraph. Perusal of materials on record and submissions made by the learned counsel of the party. Made it clear that consequent upon lodging of the FIR dated 11/2/2022, comma, the DN plus PS case number 4 within bracket 2/2022 under section 465/471 IPC was registered and investigated into. Stop. Upon completion of the investigation, a charge sheet, white charge sheet number 3/2024, dated 28/1/2024, under section 465/471 IPC was forwarded to the concerned court for trial by naming all the three petitioners as accused in the matter. Stop. The matter is pending trial in GR case number 3 within bracket A of 2024. You can sit down. You can wait. You just sit, take your seat. It appears that a settlement deed dated 28/11/2024 was entered into between the petitioners herein on the one part and the respondent 2 on the other part, comma, settling the dispute between them mainly on the ground that all of them belong to the same clan stroke family and residing in the same village. And had all along been enjoying a cordial and peaceful relation between them. Stop the content of the settlement deed further crystallizes that the FIR dated 11/2/2022 was lodged by the Respondent number 2, under some misunderstanding, because of, do not say under some, because of some misunderstanding, which because of some misunderstandings, because of some misunderstandings, which now have been settled and stand and stand clarified, settled and stand clarified between the parties. Stop. The parties, therefore, voluntarily, of their own accord, decided to settle the matter forever. In order to maintain the existing, in order to maintain the cordial and peaceful relation between them. Stop. The next paragraph. The decision of the Apex Court in 2012 within bracket 10 SCC 2012 within bracket, okay, 10 is outside bracket, 2012 10 SCC 30T. This is Gyansing versus State of Punjab and another. You will get it here, okay. And what is it? The decision of the and end it. Just take from here, criminal appeal number so and so versus so and so. Give a comma. Relied on by the learned counsel for the petitioner. Make it clear that the inherent power of the High Court in quashing the criminal proceeding what you say, just make it clear that the inherent power of the High Court can be exercised in matters can be exercised on the basis of compromise, settlement, entered into between the parties in dispute. Involving non-compoundable offence. Come on. If the settlement stroke compromise is found to be genuine, and there is no involvement of public element in the offence alleged, in the offence involved. Stop. The facts and circumstances involved in the present case does not show involvement of any public element in the matter. Stop. The allegation made in the FIR specifically concerns the parties specifically concern the petitioner and the respondent number 2. Anything more you want to be recorded? It's all right, I think. Oh, okay. Having considered, sit down. You don't say having regard to, having regard. Give a paragraph and then you say having regard to the. In fact, that the dispute has been settled between the offender and the complainant voluntarily out of their free will. And since the settlement stroke compromises aimed at boosting the existing cordial and peaceful relation between the parties. This court deem it fit and appropriate to allow the prayer made by the petitioners in this criminal petition. Resultantly, the further proceeding of GRPs number 3A, 3 within bracket A, 2024, under section 465 to 471 IPC, pending before the Judicial Magistrate First Class Shillong, Judicial Magistrate First Class, Shillong, shall stand quashed. The criminal petition stands allowed. There may be some correction here, there. Yes.